Welcome everyone to the Talking Animals Law and Philosophy series. This is the second event in the Easter term. My name is Raphael Fazel. I am the Executive Director of the Cambridge Centre for Animal Rights Law. I'm just going to say a few words about the format of the Talking Animals series for people who are joining us for the first time. We're going to start with a presentation by our speaker that will last somewhere between 30 to 45 minutes, and we'll then have around about 40 minutes for Q&A and discussion. We will end this event at 2:30 p.m. UK time. You're all warmly invited to participate in the discussion. If you'd like to come in with a question or with a comment, can you please use the raise hand function? You'll find that under the reactions button on the bottom of your Zoom app. If you're on a train somewhere or you sort of can't use your video and microphone, you can also type in your questions or comments in the chat, and I can then feed them to our speaker. I will have all the microphones muted until we get to the discussion part. We are recording the presentation bit of this event, and I'll later upload the link to our website and YouTube if you want to watch it again or send the link to a friend. Okay, I think that's all in terms of just how the format works. And it is now my great pleasure to introduce our speaker today, Jane Kotzmann. Jane is Alfred Deakin Postdoctoral Research Fellow at Deakin Law School in Australia, where she is investigating the statutory interpretation of animal sentience laws and tries to identify the real-world outcomes and impacts. Jane's got degrees in commerce and law and a PhD in human rights law from Deakin University, as well as a postgraduate diploma in teaching from the University of Melbourne. Jane's research interests extend to animal rights and more broadly animal law, in particular the extension of international human rights to non-human animals and international and comparative perspectives on animal law as well. Her work emphasizes the interconnectedness between humans, non-human animals, and nature, and highlights the significant social problems like climate change and zoonotic diseases that have roots in the human exploitation of animals. Jane recently published a fantastic piece in the Oxford Journal of Legal Studies called Sentience and Intrinsic Worth as a Pluralist Foundation for Fundamental Animal Rights. And she's going to be telling us more about that piece today in her presentation. Jane, thanks so much for being here. The floor is yours.
Thank you so much, Raphael, for that very generous introduction, and thank you for inviting me to come to talk to everybody. And also thank you to everybody for being flexible in your timing. It's currently 10 p.m. over here, so forgive me if I look a little sleepy. I'm older than I used to be, and so this is actually my bedtime. Never mind. I will start by sharing my screen. There we go. So hopefully I'm going to assume that that's good, and if it's not, please let me know. Yes. So as Raphael has foreshadowed, today I'm going to talk to you about sentience and intrinsic worth as a pluralist foundation for fundamental animal rights, based on a piece that I did publish recently, although I've added a little bit to it since then. This first slide just has a few headlines from recent news, which I thought was useful to highlight the reason why what I'm talking about is actually contemporary and important, and not just pie in the sky kind of animal rights talk. Those of you, I'm going to assume most of you are probably in the Northern Hemisphere and probably therefore haven't seen the news that's been in the headlines in the past week, at least in Australia, but probably the Southern Hemisphere, New Zealand in particular, more broadly. There was footage released perhaps a week ago by a prominent animal rights organisation, the Chris Delforce, who some of you may be familiar with, actually hid himself in the roof of a factory farm and stayed there throughout the whole night and filmed the gassing of pigs. It's quite horrifying. When you think of gassing pigs so that they become unconscious, perhaps it might feel somewhat peaceful. And what the footage shows is not peaceful in any way. And so I've included this headline just to demonstrate that what we're talking about, animal rights, is actually something that's important, because what's happening in relation to animals, many animals, billions of animals in the world, is, in I think probably many people's view, not okay. Certainly, I think, goes beyond what you might consider to be necessary pain and suffering. The second link comes from a recent Brooks Digest. If you were signed up to that newsletter, leaked documents show that Brazil and Argentina interfered with climate report that recommended transition to plant-based diet. And I think this is interesting in a couple of ways. Firstly, I think it highlights the very significant commercial interests that are vested in the continued exploitation and thus pain and suffering of animals. And because of that vested interest, I think it's really important, and I think we do realise that it's going to be very, very difficult to change the legal paradigm that we take in relation to animals. The second thing that I think is important, though, is that it highlights that not only are animals impacted by human practices, but that also when we inflict pain and suffering on animals in some circumstances, that actually can go on to have an impact on human rights as well. And in this case, it's the infliction of pain and suffering on agricultural animals that can or does go on to contribute to global warming, which in turn does and will continue to prevent many humans from enjoying their human rights. The final link I have there is in relation to recent recognition of wild animal rights in Ecuador. And I think this, perhaps again, it's very hopeful, but I think the recognition of rights of animals in Ecuador suggests to us that perhaps animal rights may become a reality. So in terms of where I'm going to go with this talk, I'm going to talk about a few things. Firstly, I'm going to talk about building an animal rights theory and contextually why I think that's a good thing to be doing at this point in time. Then I'm going to talk to the question of foundations. So if we're going to build an animal rights theory, why would we start with talk of foundations? Then I'll turn to sentience and intrinsic worth, being the criteria that I put forward for a foundation for prospective animal rights. And then I'll outline 4 reasons why I think these criteria are good ones to use. Firstly, that they're already legally recognised. Secondly, that dignity, at least in many people's accounts, forms the foundation for human rights law. Thirdly, that sentience has a strong link with the interest theory of rights. And fourthly, that sentience also can be clearly linked to one of the major reasons put forward for human rights, being the prevention of unnecessary pain and suffering. So in terms of building an animal rights theory, so this is just largely context in terms of why we need to change the legal paradigm here from one of welfare to one of rights. I'm probably speaking to the converted when I say that contemporary animal welfare laws are not adequate. They certainly could be improved. Could they ever be sufficient? I'm not sure. I would probably say no. Some people may say yes, but that's not really I suppose what I want to talk to today, what I want to talk to is, well, if our contemporary laws and the way in which they've developed over time are inadequate, how could we reframe our fundamental approach to animals? Supporting that, I suppose, the increasing prominence of animal rights in scholarship, politics, and law suggests that animal rights is something worth thinking about and talking about and potentially moving to. In tandem with that, we have public awareness and concern for animals. So we have politicians talking about animal rights. We have some legal systems embracing animal rights. We have scholarship talking about animal rights. And of course, all that discussion flows through to the public. And we have things like documentaries and an On Human Rights Project and so forth. And this has resulted in increased awareness and concern for animals amongst the public. So we have public appetite in this space for change. I'm not sure actually if many of you are aware, but there was a recent survey undertaken in Australia recently. It was commissioned by the Australian government in relation to Australian agriculture, and they wanted to establish what the public's views were in relation to, in particular, farmed animals. And the vast majority, I think it was over 90%, of people felt that farmed animals should have rights, which I found quite astounding. So if we're going to move to a change of legal paradigm, if we're going to move to a recognition of animal rights, then we want to have some theory underpinning that rights framework. And so that's what I'm looking at. Of course, not the only one. I've been very fortunate to look at some other excellent work in the space, for example, Saskia Stuckey's work. But certainly there needs to be a fleshing out of rights theory in this space. So I want to start, or I have started at least, with the question of foundations. So what is the foundation, or what should the foundation for prospective animal rights be? You might say, well, why begin with foundations, Jane? Because if we go to human rights law, foundations is probably the most contentious area of human rights law, the most easily attacked, and thus perhaps it's a weak point to start. But I think you have to start there, because foundations is really the idea or fact that something is based on. It's the justification for. So if you can't justify prospective animal rights, then you're not going to be able to make a convincing argument that they should be there at all. I've got this silly picture from, the Creative Commons of the foundations falling out from under a building. And I think that's basically what happens if you don't have a strong foundation for something. The quote over on the right-hand side, actually, I should say and clarify, is from Tassiulis, but in relation to human rights. But I think easily the same question can be posed in relation to animal rights. Also at the outset, I will say that my account for foundation for prospective animal rights is a two-level account. So by that, I mean that my account relies not on a single characteristic, so not, for example, only on interests or not only on dignity, but actually on both. And that, I think, is probably largely a practical approach. Interests alone are generally, it depends who you read, but generally not sufficient to ground rights. So just having interests will not be enough. I will talk a little bit later about the interests theory of rights, but for now, let's just say interests are not enough. So if we just wanted to rest it on interests, people would probably say, well, actually you've got to have more than that. You might say the plants have interests and we don't want to give plants rights. And so it could be subject to attack. But if we look at it from more of a dignitarian perspective, so something kind of inherently valuable in animals, we see that over time, animals have historically been excluded from conceptions of dignity. that's not the case in contemporary times everywhere. And I'll talk to that in a moment. But very much in history, the evolution of the term dignity has excluded animals. And so to try and base a theory of animal rights solely on dignity, I think would be difficult. But I don't think we have to choose. I actually quite like Tassiulis's approach to human rights, that we don't have to choose. We can actually found rights on both dignity and interests. Secondly, the account that I put forward here is a pluralist account. And by that, I mean that it's based on a plurality of interests. So it's not just animals' interests in avoiding unnecessary pain and suffering. It's any of the kinds of interests that you might be able to say that animals have. I think this is useful because it allows for flexibility in relation to what rights we say animals should have or we're willing to recognise. And it also, I think, perhaps even more importantly, enables scientific knowledge to inform rights development. And this is particularly important, I think, because our scientific knowledge is very much in a state of development in this area. There is some areas where, quite frankly, we just don't know. In relation to some animals, there just isn't the research as to the sentience, perhaps, of those animals. And that's highlighted really well, I think, in the report from Jonathan Birch and his colleagues, which some of you may be aware of. Okay, so I'm going to turn now to the actual criteria that I'm talking about, sentience and intrinsic worth, or as a synonym, dignity. So when we're talking about sentience, and I know probably most of you know all of this, so I'll be very brief, we're talking about a subjective experience of the world. So you see something from your own personal perspective, and that involves having positive states, for example, emotions like happiness, joy, satisfaction, and so forth, as well as negative states as well, which tend to be the ones that we focus on, but are no more important, really, than positive states. So negative states include pain, suffering, anxiety, and so forth. We've got a fuller definition from David Mellor over on the right-hand side: capacity to consciously perceive negative or positive sensations, feelings, emotions, or other subjective experiences which matter to the animal. And I saw in one of the recent presentations in this series another definition put forward, I think, by Birch, which is just basically the ability to have feelings. So we can make it a simple definition, we can make it a complex definition, but I think by and large, most of us will understand what it is we're talking about. Whoops. I'm trying to move the little thing that, there we are. Okay, so if that's what sentience means, then I think it's important to talk about what beings are sentient. Now, as I indicated earlier, the science is not 100% on this. So there's definitely a grey area in between those columns where there's a lack of perhaps evidence and knowledge as to some beings that might fall in the sentient column, but we're not quite sure. But what we do seem to be sure about, and I'm not a scientist, so I'm talking in relation to things that I don't know a great deal about, but other scientists have said that all vertebrates are sentient, amphibians, reptiles, and fish are sentient, and also in relation to the Birch report, that most cephalopods and decapod crustaceans are also sentient. And those that are not sentient, it's quite interesting, they note that it's not because there's any kind of indicator that they're not sentient, that they don't conclude that they are sentient. I'm probably getting confusing now, but it's just simply that there isn't the research done to demonstrate that the sentience exists in those animals. In terms of non-sentient then, so which beings are we going to exclude from this circle of rights? Beings without a centralized nervous system is basically the criteria, because we take it that a centralized nervous system is indicative of sentience. So fungus, bacteria, and plants are all in the non-sentient column, which is interesting. Some of you might have noticed a recent article in Animals, the Animals Journal, around the possible sentience of plants. But that is definitely outside my expertise. Some animals are also not considered to be sentient, for example, sponges and corals. Okay, so if we turn now from sentience to intrinsic worth or dignity, so my second criteria or concept, what we're talking about here is something, a being having value in and of themselves rather than as a means to some end. Not to say that beings can't be used for purposes. Certainly humans are used for purposes all the time, but that they do have inherent value. They do have value in and of themselves, aside from being able to meet some end for somebody else. Many synonyms we see in relation to this in legislation include intrinsic value, inherent worth, inherent value, inherent dignity. In my account, these all largely mean the same thing. That said, I do have to note that, and I did foreshadow earlier actually, that dignity historically has not been inclusive of animals. And there's kind of been a resurgence in literature in that area, in that new dignitarians use the idea of human dignity to resist perceived threats to the innate moral and legal status of humans. In other words, they say, well, there's something really super special about humans as opposed to all other animals. And if we let the guard down on that, then somehow we will have an erosion of human rights. For example, George Kateb says in his book published 2011, all individuals are equal and no other species is equal to humanity. I can't actually recollect the reason that he gives for that, but to my mind, at least, it was not particularly convincing. There are problems with this approach. You know, we could spend a whole hour talking about the problems with this approach, but I'm going to go over very briefly some of the problems and then move on. So firstly, most of you will be familiar, and I'm going to the third dot point here, with the argument from marginal cases that in essence, if you want to say humans as a species are superior to all other species, then you need to be able to pinpoint some characteristic of humans that makes them special. But if you go through characteristics, and scholars have tried to identify characteristics, for example, rationality or agency, there isn't a single characteristic that will apply to all humans and no other animals. Beyond that, on a more practical level, you see from Kimlicker's research that if we actually do encourage humans to discriminate between humans and animals, the impact is not to support human rights, but actually we lead to an increased discrimination from those people between humans themselves. So if you're inclined to discriminate against other species, you will also be more inclined to discriminate against various categories of human beings as well. And the converse also being true, that if you teach people to be humane in relation to animals, it will encourage greater empathy and pro-social attitudes towards other humans. So in other words, the argument just basically doesn't stand up. Okay, so now I will turn to the 4 reasons why I say these 2 concepts are appropriate as a foundation for fundamental animal rights. The first is quite simple, really, and it's that they are already legally recognised in many jurisdictions. I think that's important because legal change, as we all know, takes a really, really, really long time. It's actually reasonably quick. I think that the concept of sentience, I think when I went back and went through the history, only took 9 years from advocacy to implementation. But I think in legal terms, that's actually really quick. Legally, things can take a really, really long time. And so if we want to come up with some alternative foundation, to get that legally implemented will take some time. Of course, that's not a reason in and of itself to not to prefer something else, but I do think it's an advantage that these concepts are already in the law. And already being in the law also means that they're reflective of public opinion. And I think that is important as well because it indicates to us that the public is potentially already persuaded of this foundation for animal rights and perhaps therefore more likely to be persuaded of the rights themselves. So in terms of how these concepts are recognised in the law, it can be argued that they are and have been for some time implicitly recognised. And it can also be quite clearly stated that they are expressly recognised in many instances as well. The implicit recognition is probably the more difficult argument to make, but I'll briefly go through both. In fact, this is probably an argument here on this slide that is commonly kind of assumed, that animal welfare laws do implicitly recognise sentience. I think they do, but it could be argued that our contemporary welfare laws are really just recognition of the value of private property or the importance of treating animals well for public values. So there's certainly other reasons why that we can point to account for contemporary animal welfare laws. Nevertheless, I think there are certainly instances where we can point and say, no, it does seem to be some implicit recognition that we understand that animals are sentient. For example, there I've got paragraph 1 of the Finnish Animal Welfare Act. States the Act aims to protect animals in the best possible way from suffering, pain and distress. It doesn't obviously expressly reference sentience, but in order to have suffering, pain and distress, an animal needs to be sentient. Similarly, we could make the argument that there is implicit recognition of intrinsic value or dignity. And here you'll see a reference to the case from Oregon of State and Crow, where the Court of Appeals held that the relevant legislation evinced an intention to protect individual animals rather than the general public. So that's obviously an express statement that that was the case, or that is the case in Oregon. We don't have the case law in all jurisdictions to indicate to us whether or not other animal welfare legislation is in place to protect animals or for some other reason, but presumably in some instances it is there to protect the intrinsic worth of animals, at least to some degree. We also, intrinsic recognition doesn't matter so much anymore because we actually now also have express recognition in many jurisdictions. So in relation to sentience, many of you, I'm sure, will be aware of the trend towards express legal recognition of animal sentience in multiple jurisdictions, and you'll see I've got many listed there. I've got just a few by way of examples. So the TFEU, many of you I think will be aware of, states since animals are sentient beings, so clearly an express recognition. The Oregon laws state animals are sentient beings capable of experiencing pain, stress, and fear. This is an interesting definition because it only includes the negative aspects of sentience and doesn't expressly reference the positive aspects. The UK Act is also interesting because rather than simply acknowledging sentience, it actually establishes an animal sentience committee with functions relating to the effect of government policy on the welfare of animals as sentient beings, although I note that the chair of the committee, is it the chair, was a former farmer, so I'm not sure how effective that will be. It'll be interesting. Express recognition of intrinsic value or dignity has also been seen in recent times, again in a number of jurisdictions. So in the Swiss Animal Protection Act, we have the purpose being the protection of the dignity and welfare of animals. In the Netherlands Act, we have recognition of the intrinsic value and a linkage between the concept of intrinsic value and the status of animals as sentient beings. Okay, so my second reason why I think these concepts would provide a good foundation for fundamental animal rights is because, at least in relation to the second concept, being intrinsic worth or dignity, dignity is generally considered to be the foundation for human rights. And I think that's important because I share the views of scholars like Alistair Cochrane, Saskia Stuckey, that if we're talking about prospective animal rights, really we're talking about a subcategory of sentient rights. So human rights and animal rights really being part of the same mission or sharing the same purpose and the same theory. So human dignity is said to underpin contemporary human rights. We can see that in the preambles to documentation that forms the International Bill of Human Rights. The ICCPR and ICESCA state rights derived from the inherent dignity of the human person. Whilst this is the case, of course, dignity, as I indicated earlier, has been subject to significant criticism, and I think perhaps in many ways fairly so, because it's not really the kind of legal term that you can easily define. It is to some degree vacuous, in other words, lacks meaning to some degree. And if you look at the history of the UDA, the Universal Declaration of Human Rights, you can see that different people thought it meant different things. So they were all imposing their own view of what dignity actually meant onto the wording. And that's quite possibly why it was used as well, because it meant they were able to bring people together to agree on human rights, even though they had perhaps differing understanding of what the purpose or what the foundation for those rights actually was. Nevertheless, even though I think to some degree the concept is a bit vacuous is probably too harsh, but certainly lacks concreteness, it can be distilled down to essential characteristics: recognition of inherent value, equal to all persons, so an aspect of equality that has to be respected rather by others, so an aspect of relationality in there as well. And not only can it be kind of defined in that way, but also it has operated, at least in the human rights space, to enable the drawing together of international support for human rights. And I think potentially we could have a similar scenario in relation to animal rights. Some people would say that I'm wrong on this, but nevertheless, I think if you look through the literature, there isn't really a compelling theoretical reason for excluding a concept of animal dignity. And recognition would, I think, highlight that human rights and animal rights are really subcategories of sentient rights. Moreover, I also think that if you have a category like dignity out there in the law, and it applies only to humans and not other animals, then your implication is that humans are superior to other animals. Now, that may be the view that many people have, but I think that view is changing. And I think many people these days would say that other animals do have moral status in a similar way to humans, and I think therefore we should be including non-human animals in that category of dignity as a signal of their equal moral status. Okay, my third reason why I think this is a good idea is because sentience connects quite closely with the interest theory of rights. There are two main theories of rights that exist in the scholarship. One is the will theory of rights, and it's not particularly useful for animals, and so I probably am not going to talk about it. The interest theory of rights, though, is particularly helpful for animals. Basically, the interest theory of rights is that to have rights, a being has to have interests. And of course, if we say animals are sentient, well, sentient beings have interests, because if you can have feelings, then you can have an interest in feeling positive emotions and an interest in avoiding negative emotions. Of course, I foreshadowed earlier, having interests isn't enough to lead to recognition of rights. We need to go beyond that for the interest, and I think this is Raz's definition from memory, but for the interest to be protected as a right, it has to be of sufficient importance to provide a basis for imposing a duty on another being. So it's not enough to say, well, I've got an interest in living in a mansion in the Bahamas. I have to actually be able to say, well, this interest is so important that it should impose an obligation on others to do something in relation to that interest. Perhaps not as expressly as I've made the argument here, but we can see animal rights literature does make this connection as well. For example, in Frank Uni's quote here, he states animals and humans are similar in that they are sentient, so the sentience is referenced. If animal interests in not suffering, so to be sentient means that you have interests in not suffering, are to be morally significant, then we must apply the principle of equal consideration and extend to animals a basic right. So you can see the connections being made here between sentience, interests, and thus rights. Similarly, with Cochrane's argument, animals have interest in not suffering and in not being killed. So because they are sentient, they can suffer, and therefore they have interests in not experiencing those negative emotions, and those interests are sufficiently important to constitute rights, so lead to recognition of rights. And my final argument is in relation to the connection between sentience, pain, and suffering. So looking, focusing here on the sentience concept. In this respect, and again, this is probably controversial as a viewpoint, but nevertheless, some human rights theories posit that the primary purpose of human rights is to prevent pain and suffering. And I think consideration of the historical background to the International Declaration of Human Rights probably supports that it was very much a response to the atrocities that occurred during World War II. A couple of examples. Dzinnis argues that human rights are granted in the emotional reaction to preventable suffering. Ipendra Baxi argues that the historic mission of contemporary human rights is to give voice to human suffering, to make it visible and to ameliorate it. And I tend to agree with these points of view. I think the primary purpose of rights has to be to prevent unnecessary pain and suffering. Do rights have a role in allowing beings to have a good life? Possibly, yes, but I think that that is secondary to this primary goal of preventing unnecessary suffering. And I think that resonates, well, at least for me, that resonates in experience of animals, many animals in contemporary times, in terms of the pain and suffering that is unnecessary, at least in some perspectives, that I think is probably what's driving a push towards recognition of animal rights. So I'm going to finish up my talk there. I think I've come in within my 30 to 45 minutes. So I'll stop talking. I have to have my cute koala picture there, and we'll see what interesting questions you have for me and whether I can answer them.